1985 and completed his LLM in 1991. He contributed extensively to judicial administration and reforms until 2019. He served as the first Chief Justice of the newly established Andhra Pradesh High Court, later as Chief Justice of the High Court of Sikkim. I kindly request Honorable Ms. Justice S. Sujata, Judicial Magistrate, CAT Bangalore Bench, to felicitate Honorable Justice Satish Chandra Sharma, Judge, Supreme Court of India. Born on 30th November 1961 in Bhopal, Justice Sharma excelled early in education, graduating in science with distinction in 3 subjects and later securing his LLB degree with 3 university gold medals from Dr. Hari Singh Gaur University, Sagar. He was appointed as Additional Central Government Counsel in 1993 and Senior Panel Counsel in 2004. And now I request Honorable Justice Sunil Thomas, Judicial Member CAT Ernakulam, to felicitate Honorable Justice Prasanna B. Varale, Judge, Supreme Court of India, Chief Justice of the newly reorganized Telangana High Court. And now I request Honorable Justice Sunil Thomas, Judicial Member CAT Ernakulam, to felicitate Honorable Justice Prasanna B. Varale, Judge, Supreme Court of India. Justice Varale began his illustrious legal career at the Aurangabad bench of Bombay High Court, training under the renowned Sri Satya Narayan Loya and gaining expertise in both civil and criminal law. In October 22, he assumed charge as Chief Justice of the Karnataka High Court, and on 25th January 2024, he was sworn in as a judge of the Supreme Court of India. I now request Honorable Justice Narendra K. Johri, Judicial Member CAT Patna Bench, to felicitate Honorable Justice Vijay Bishnoi, Judge, Supreme Court of India. Born in Jodhpur in 1964, Justice Bishnoi began his legal career in 1989. Over the years, he represented a wide range of institutions, including the central government, various departments of the government of Rajasthan, BSNL, BPCL, universities, and cooperative banks. He was elevated as a judge of the Rajasthan High Court in 2013. I now request Honorable Justice Rajiv Joshi, Judicial Member Bench, to felicitate Honorable Dr. Jitendra Singh, Minister of State, Independent Charge, Prime Minister's Office, and also holding charge of the Ministries of Science and Technology, Earth Sciences, Personal Public Grievances and Pensions, Atomic Energy and Space. Dr. Jitendra Singh is a remarkable leader whose journey in itself is an inspiration. Hailing from the hilly districts of Doda in Jammu and Kashmir, he rose through dedication, scholarship, and service to become one of the most respected voices in public life today. A professor of medicine, prolific researcher, and renowned author, he has contributed over 5,000 articles, 5 books, and path-breaking research, including pioneering work on stress-induced diabetes among Kashmiri migrants, a study later acknowledged by the World Health Organization. I now kindly request Honorable Justice B.K. Srivastava, Judicial Member CAT Bangalore Bench, to felicitate Honorable Shri Arjun Ram Meghwal, Minister of State, Independent Charge. Shri Meghwal's journey is truly inspiring, from a distinguished career in the Indian Administrative Service in Rajasthan to becoming a 4-time Member of Parliament from Bikaner since 2009. In Parliament, he has held several important responsibilities. He served as Chief Whip of the BJP in the Lok Sabha and Chairman of the House Committee from 2014 to 16. I kindly request Learned Shri Enrolling with the Bar Council of Tamil Nadu in 1977, he soon made his mark in the Supreme Court of India, joining the chambers of the eminent Pavani Parmeshwara Rao. In 1997, he was designated a senior advocate by the Supreme Court, a recognition of his legal acumen and deep commitment to justice. Honorable Sri R. Venkataramani has appeared in several landmark matters, including Mr. Justice Ranjit Vasantrao More, born on 4th November 1959 in Satara, Maharashtra, is a distinguished jurist who began his legal practice in 1983. He was elevated as a judge of the Bombay High Court in 2006, later served as the High Court of Meghalaya and became the Chief Justice of the Meghalaya High Court in 2021. On 30th July 2022, he assumed charge as chairman of the Central Administrative Tribunal, where he continues to lead with vision and dedication. Thank you, esteemed dignitaries, and thank you to our respected members for carrying out this ceremony of honor. Ladies and gentlemen, please join me in the warm round of applause for all our distinguished guests. It is now time to formally commence our inaugural session. To deliver the welcome address, I have the honor of inviting Honorable Mr. Justice Ranjit Vasantrao More, Chairman, Central Administrative Tribunal.
Mr. J.K. Maheshwari, Judge of the Supreme Court, Honorable Justice, Judge of the Supreme Court, Honorable Justice Mr. Vijay Bishnoi, Judge of the Supreme Court, Dr. Jiten Singh Ji, Honorable Minister of State for Personnel, Public Grievance and Pension, and Ministry of Science and Technology, Honorable Minister of State of Law and Justice, Sri Arjun Ram Meghwal Ji, Learned Attorney General for India, Sri R. Venkataramana Ji, Honorable Chief Justice of Delhi High Court, Sri D.K. Upadhyay, Honorable Judges of the High Court of Delhi, Chairpersons of the various tribunals, Learned Additional Solicitor Generals of the India, Members of the Central Administrative Tribunal and other tribunals, Secretaries and Senior Officers of the Government of India, former Chairman and members of the CAT, members from the bar, distinguished guests, ladies and gentlemen. Good morning to all of you. It is my profound honor and privilege to welcome you all to the 10th All India Conference of the Central Administrative Tribunal. This is a significant occasion, not just for us within the tribunal, but for the entire administrative justice system in our country. It was through 42nd Amendment to the Constitution of India in the year 1976 that Chapter 14A was added, paving way for the constitution of the Administrative Tribunal. It was in the year 1985 that the Central Administrative Tribunal was set up under Article 323A of the Constitution of India, opening a new vista in the sphere of adjudication of service matters of the central government employees with respect of their service conditions. The Honorable Supreme Court, in its judgment in S.P. Sampath Kumar, examine the validity of the Act extensively, and even while upholding the validity of the Act, issued certain important directions for establishment of benches of the tribunal, not only at the seat of the High Court in the state, but also at the places where benches of respective High Court functions. As a result of this, the benches of Administrative Tribunal were constituted at most of the seats of the High Court, as well as their benches. While at some places, regular benches are established, in other cases, circuit benches are held, depending upon the pendency. As of now, this tribunal operates for 19 regular and functional benches with 22 circuit benches. The total sanctioned straight of the chairman and members of the CAT is 70, against which at present it is functioning with 64 members. I extend my warm thanks to the Honorable Minister and Government of India for issuing appointment orders for filling of remaining unfilled vacancies few days back. Some of the honorable members recently selected but are yet to join are amongst us today. It is worth to mention that out of 19 regular benches of the tribunal, 11 benches are functional in its own building. The remaining 8 benches are housed in the accommodation provided by the respective state government. Under the visionary leadership of our Prime Minister, Sri Narendra Modi ji, and through good offices and concerted efforts of Honorable Dr. Jiten Singh ji, Minister of State for Personal Public Grievance and Pensions, we have been successful to shift our own building from rented accommodation in few benches in the recent past. However, in few benches like in the case of the principal bench, New Delhi, where we have our own building for quite a long time, a need for additional space is felt to smoothly cater the requirement of enhanced caseload. I can say with firm conviction that prime focus of the members of the tribunal has been to overcome the burden of pendants of the cases and restore the confidence of all stakeholders in the system. For the period since 1998 till May 25, a total of approximately 7 lakh cases have been disposed by this tribunal. 91% orders of judgment have attained finality. For the remaining 9% cases, the parties have challenged the decision of tribunal before the Honorable High Court, and the Honorable High Court have been pleased to uphold orders of this tribunal in around 67% cases. Therefore, this tribunal has been successful in settling over 94% of the cases, which is considered to be an impressive performance record. Apart from the central government employees, as on date, employees of 230 other authorities, corporation and society under the union government are within the jurisdiction of the tribunal. A proposal for extension of jurisdiction of this tribunal to the organization similar to 230 organizations like Central Public Sector Undertaking, Nationalized Bank, Nationalized Insurance Company, Central Universities, Institute of National Importance, etc. have been taken up with the government. This would further fulfill the very purpose for which the tribunal was created, that is, decrease the load of jurisdictional high court. At last, I welcome all of you in this August gathering. Let it be a platform of introspection, innovation, and institutional strengthening. I invite all members, judicial and administrative, to actively participate in the program today and raise the bar of administrative justice in our nation. Let us recommit ourselves to the ideals of the justice that is timely, accessible, reasoned, and equitable. On behalf of entire tribunal fraternity, I extend my heartfelt gratitude to Honorable the Chief Justice of India, the Honorable Judges of the Supreme Court, Honorable Ministers of the Union Government, Attorney General of India, Honorable Chief Justice and Judges of the Delhi High Court, Chairpersons of the Tribunal, Additional Solicitor Generals, members of the bar, other dignitaries, for their august presence here today. Let us move forward, not just as a custodian of the service law, but as a reformer in larger ecosystem of administrative justice. Thank you. Jai Hind.
Thank you, Honorable Justice More, for those gracious words and for setting the tone for this conference. We now have the privilege of hearing from the nation's foremost legal advisor, a jurist of extraordinary depth and wisdom, Sri R. Venkataramani, Attorney General of India. With over 4 decades of distinguished practice, he has appeared in some of the most significant constitutional and public law cases, contributed to environmental and human rights jurisprudence. Please welcome them.
Honorable the Chief Justice, Judges of the Supreme Court, and very distinguished audience, and when 2 ministers and the creamy layer of the Supreme Court of the dais, I suppose many things get resolved. And walking an extra mile is always said to be a good way to do it, and I thought let me walk this little extra mile to greet all of you on an occasion like this. 39 years ago, the idea of having a tribunal was conceived, and much before that. It's important to notice that we have come a long way from breaking ground from the English understanding of tribunals. And in 1950s, early 50s, whether under Article 136, we will have a specially petitioned against the industrial tribunal, Supreme Court was grappling with those issues. For good, I think we have put all that ideas to rest. Tribunals, for all practical purposes, are courts. Let us no longer, be concerned about that issue. And if they are courts of an important element of our administration of justice. Having said that, I remember in '86 when the tribunal was set up, I see in my presence in the front row many leading lawyers who have practiced in the High Court and in the Tribunal, with many of whom had jostled shoulders, and the contribution which we are trying to make to the emerging jurisprudence of service law in our country. We had tall judges like Chief Justice Madhav Reddy, and I remember those days when the idea whether tribunal will really grow at all. We had a lot of doubting Thomases. I think those doubting Thomases have been laid to rest. We no longer have those among them. It's good that we keep on celebrating the emergence and the birth and the growth of tribunals in our country, notwithstanding the fact that we still have some problems. Problems are always there. No court, no institution grows without problems. We have problems of infrastructure, we have problems of appointment of judges, so on and so forth. But that's besides the point. And recently, when I was asked to look into the Tribal Reforms Act, and we've been in a series of discussion at the executive level and also among the practitioners, these are some common issues. I suppose it's important for us to go beyond these issues and to understand that how to strengthen this tribunal in order that, number one, the selection, the appointment gets into a quality set of people who are coming into the institution. With quality comes equipment and integrity. With equipment and integrity comes fruitful outcomes. What else do you want? And I suppose we're all wedded to this idea of ensuring that tribunals are firmly rooted. The tribunals play an important part in the administration of justice in our country, and we have the Supreme Court and the High Courts playing an important role in ensuring they function within the broad parameters of our constitutional outlines. I don't think we need also to get into the question of judicial review versus lack of judicial review. All that I think will get settled over a period of time. What is important is within the broader constitutional parameters, will the tribunal be strengthened to ensure the justice delivery system is comfortable, is full of certainty, and it doesn't admit of all those doubts we talk about, whether there is extraneous factors which enter and corrode the administration of justice issues. Once we take care of quality, I suppose everything else will be taken care of. In some private conversation, judges keep telling me about quality. I'm sure over a period of time, with the two honorable ministers being here, we'll also be able to resolve all those issues. And that's why we need to have a round table more often as possible, where this kind of issues are sorted out at the executive level in some matters coming on the litigated on the judicial level. I think it's important to do that. I'm sure the two honorable ministers will be able to spare a little more time and ensure that. Yesterday I was in Bombay in a different context. We were talking about the Indian Chamber of Commerce at a Global Business Summit. Question was, how do you ensure that the Indian judicial system, our legal framework, is able to match up to global requirements and needs and demands? And therefore, if you look at not only a commercial court, I think every court in our country, like if you look at land resource, we don't look at merely a property issue. Land today is an important part of our human resources and economic resources, financial resources. So you look at every court as part of a thread, like a bouquet of flowers. Every court is part of contributing to the national economic, political, and social growth. I think no tribunal can be probably said to be higher, no tribunal can be said to be lower in this hierarchy. There's no hierarchy at all. I suppose in this understanding, I'm sure with the administrative tribunal having played an important role in ensuring equity and justice. So one can certainly talk about the jurisprudence through the administrative tribunal is no less than, for instance, you look at the international level. International administrative tribunals, about international organizations, sometimes they borrow from Indian jurisprudence. I can say from my own experience how it's happening. So it's important that we have come of age. And once you have come of age, we must celebrate our coming of age as long as possible and as expeditiously as possible and as often as possible. Let us do it, and I'm wishing all of you to be here today with a wonderful involvement and engagement. I'm sure the Chief Justice of India will also be able to give us a little more insights before he demits office and give us a little more strength to ensure that the tribunals will be a proud part of our jurisprudence in history. Thank you so much for your attention.
Thank you, sir, for those profound and thought-provoking remarks. It is now my honor to invite Honorable Shri Arjun Ram Meghwal, Union Minister of State, Independent Charge for Law and Justice and Minister of State for Parliamentary Affairs. Yes. He has held important portfolios across finance, water resources, heavy industries, culture and law, and has also been recognized with the Sansad Ratna Award 3 times and the prestigious Sansad Maharatna Award. We are privileged to hear him.
10th All India Conference of the Central Administrative Tribunal on this occasion, on the dais, Honorable Mr. Justice Bhushan Ram Krishna Gavai, Chief Justice of India, and he is the chief guest of today's program. Other judges of the Supreme Court, Justice J.K. Maheshwari ji, Justice Satish Chandra Sharma ji, Justice Prasann B. Barale ji, Justice Vijay Bishnoi ji, and Honorable Dr. Jitendra Singh ji. He is my colleague in Parliament. That I will not say, sir. That is confidential. आप जनरली हमें साथ साथ देखते होंगे ना पार्लियामेंट में, देखते हो कि नहीं देखते बताओ? हाँ, पर वो बात मैं अभी करूंगा नहीं, आज दूसरी बात करूंगा. वेरी गुड. आप एक शेर सुनाना, सब अच्छा रहेगा. ऑनरेबल डॉक्टर जितेंद्र सिंह जी, मिनिस्टर ऑफ स्टेट, PMO, पर्सनल, PG एंड पेंशंस, डिपार्टमेंट ऑफ स्पेस एंड एटॉमिक एनर्जी, मिनिस्टर ऑफ स्टेट इंडिपेंडेंट चार्ज, अर्थ साइंस, साइंस एंड टेक्नोलॉजी. जस्टिस मोरे साहब, जो आज के प्रोग्राम को सबको अब इन्होंने इनवाइट किया हमको, और श्री R. वेंकटरमणी जी, अटॉर्नी जनरल ऑफ इंडिया. आप सबको नमस्कार. हमारे सामने चीफ जस्टिस दिल्ली हाई कोर्ट भी बैठे हैं और जज भी बैठे हैं. मैं कईयों के चेहरे देख रहा था, बहुत सेक्रेटरीज भी बैठे हैं हमारे मंत्रालयों के, कई ऐसे लोग भी बैठे हैं जो कैट से जिनका वास्ता पड़ा, कुछ ऐसे बैठे हैं जिनको कैट में सफलता मिली, कुछ ऐसे भी देखा हूं मैंने बैठे हैं जिनको कैट में सफलता नहीं मिली. सबको नमस्कार. सर, माननीय भारत के मुख्य न्यायाधीश जो हमारे BR गवई साहब हैं, उनके समक्ष ये आज 10वें अखिल भारतीय सम्मेलन का जो अवसर आया है, हम सबको मिला है, उसके लिए मैं आप सबका स्वागत करता हूं. ये सम्मेलन केवल औपचारिकता नहीं रहे, ये मेरा विशेष अनुरोध रहेगा, बल्कि ये न्यायपालिका, प्रशासनिक न्याय प्रणाली के बीच एक समन्वय, एक संवाद का महत्वपूर्ण मंच बने, ये मेरी अपेक्षा रहेगी. और ये सम्मेलन चूंकि माननीय मुख्य न्यायाधीश हमारे BR गवई साहब की गरिमा में उपस्थिति में हो रहा है, तो ये सम्मेलन और महत्वपूर्ण बन जाता है. और कैट ने भी उसी भावना को आगे बढ़ाते हुए लाखों मामलों में न्याय उपलब्ध कराया है, लेकिन फिर भी बहुत इम्प्रूवमेंट की ज़रूरत है इस दिशा में. तो इसमें विशेष रूप से चिंतन, मनन, मंथन विशेष रूप से होना चाहिए इस सम्मेलन में, ऐसी मैं अपेक्षा करता हूँ. देखिए, लगभग 4 दशकों से जो हमारा कैट है, ये हमारे देश के जो लोक सेवक हैं उनके लिए न्याय की आधारशिला रही है. मैं तो जब फाइलें देखता हूं तो ऐसा देखता हूं कि कई बार जजमेंट बहुत अच्छा है, लेकिन हमारे विभाग जो हैं वो कहते हैं नहीं साहब, हमें तो अपील ही करनी है. ये जो प्रवृत्ति है, इसको हम कैसे ठीक करें, ये सम्मेलन का विषय होना चाहिए. अब किसी अधिकारी ने कभी लिख दिया कि ये ठीक नहीं है, उसके खिलाफ कोई कैट में गया, कैट का फैसला पक्ष में आ गया, अब वो अधिकारी नहीं मर जाए, इसलिए हमें तो अपील करनी है. और जब वो आदमी रिटायर हो जाएगा तब कहने अब हम अपील नहीं करनी, ये क्या है? इसको थोड़ा ठीक करना पड़ेगा. ये हमें डे टू डे देखने में को मिलता है ये विषय, तो ये इसके चिंतन में आना चाहिए. कैट हमारे संवैधानिक न्यायालयों के बोझ को भी कम करने में अहम भूमिका निभाता है. इसके लिए कैट के सभी सदस्य, आप सभी सदस्य बैठे हैं, सभी सदस्य मिले भी थे, कैट के सभी सदस्यों, अधिकारियों, कर्मचारियों को भी इस अवसर पर मैं हार्दिक साधुवाद देता हूं, वंदन करता हूं, आप सबका अभिवंदन भी करता हूं. आने वाले समय में जो चैलेंज हमारे सामने रहेंगे वो कोर्ट से लेकर के AI संचालित अनुवाद से लेकर के डिजिटल केस मैनेजमेंट को लेकर के हम एक क्रांति के साक्षी बनेंगे और जल्दी ये चैलेंज हमारे सामने उपस्थित हो भी रहे हैं। कैट को अपनी विशेषज्ञ प्रकृति और अखिल भारतीय उपस्थिति के कारण इस क्रांति का केवल एक हिस्सा ही नहीं बल्कि एक अग्रणी भूमिका निभाने के लिए आगे आना भी चाहिए। ये भी एक विषय आज के सम्मेलन में होना चाहिए। देखिए, कई बार ज्योग्राफी कि मैं तो दूरस्थ क्षेत्र का आदमी हूं, इसमें कई बार उसको न्याय दिलाने में हम कठिनाई महसूस करते हैं। तो आने वाले समय में ई फाइलिंग, वर्चुअल हियरिंग, डिजिटल रिपोजिटरी, ये केवल सुविधाएं नहीं हैं, ये न्याय का लोकतंत्रीकरण करने के शक्तिशाली साधन भी है। और हमें ये सुनिश्चित करना है कि ज्योग्राफी अब न्याय के मार्ग में बाधक नहीं बनेगी, ये हमें सुनिश्चित करना है। आज के सम्मेलन में मुझे लगता है यही सभी चीज़ें आपके समक्ष आने वाली है। मैं पुनः हम एक ऐसे भविष्य की कल्पना करें जहां केंद्रीय प्रशासनिक अधिकरण दक्षता, पारदर्शिता और नवाचार के लिए एक वैश्विक मानक बन जाए। एक ऐसा भविष्य जहां प्रौद्योगिकी और न्याय साथ साथ चले, ये सुनिश्चित करते हुए कि प्रत्येक लोक सेवक के लिए न्याय न केवल हो बल्कि शीघ्र, सस्ता और सहज रूप में होता हुआ दिखना भी चाहिए। मुझे पूर्ण विश्वास है कि भारत के मुख्य न्यायाधीश जी के मार्गदर्शन और यहाँ उपस्थित सभी लोगों के सामूहिक ज्ञान और संकल्प से हम इस दृष्टि को वास्तविकता में बदल देंगे। मैं ये भी कहना चाहूँगा कि न्याय की सबसे बड़ी पहचान उसकी तेजी, पारदर्शिता और निष्पक्षता है। हमें मिलकर ये सुनिश्चित करना होगा कि प्रत्येक सरकारी कर्मचारी को, चाहे वे किसी भी स्तर का हो, न्याय प्राप्त करने में अनावश्यक देरी नहीं होनी चाहिए। मैं इस अवसर पर केंद्रीय प्रशासनिक अधिकरण के सभी माननीय अध्यक्षों, सदस्यों और कर्मचारियों को साधुवाद देता हूं, जिन्होंने अपने परिश्रम और समर्पण से इस संस्था को विश्वसनीय बनाया है। अंत में मैं यही कहना चाहूँगा कि न्यायपालिका और कार्यपालिका का ये साझेदारीपूर्ण प्रयास भारत को एक ऐसी न्याय व्यवस्था की ओर अग्रसर करेगा जहां न्याय केवल एक आदर्श न होकर प्रत्येक नागरिक के लिए सुलभ वास्तविकता होगा। जय हिंद। बहुत बहुत धन्यवाद। आभार।
Thank you, sir, for those inspiring and insightful reflections. It is now my privilege to invite Honorable Dr. Jitendra Singh, Union Minister of State Independent Charge, Prime Minister's Office, Personnel, Public Grievances and Pensions, Science and Technology, Earth Sciences, Atomic Energy and Space. Please welcome Honorable Dr. Jitendra Singh.
Thank you, Justice More, for placing this beneath my feet. With everybody around being taller in intellect, at least I can pretend to be physically taller now. Honorable Chief Justice of India, Mr. Justice B.R. Gawai, Honorable Judges of the Supreme Court, संसद में हमारे वरिष्ठ साथी, हमारे घनिष्ठ मित्र और लोकप्रिय नेता, धरती से जुड़े हुए ऐसे आदरणीय भारत के कानून मंत्री श्री अर्जुन राम मेघवाल जी, ऑनरेबल चेयरमैन ऑफ द सेंट्रल एडमिनिस्ट्रेटिव ट्राइब्यूनल जस्टिस रंजित मोरे, लर्नड अटॉर्नी जनरल ऑफ इंडिया, Honorable Chief Justice and Judges of the High Court, Honorable Members of the CAT, learned Additional Solicitor Generals of India, Honorable Members of the Bar, distinguished guests, ladies and gentlemen. At the outset, I have to compliment you and also thank Chairman for making me a part of this very momentous occasion, the 10th All India Conference of CAT. And I have been a close witness to the manner in which Justice More has been very passionately preparing for this event. And in fact, for the last almost 6 months, he's been reminding me, if not 6 times a day, at least 6 times a week, that I have to make myself available in Delhi on the 19th of September, on the 20th of September. So that's the manner in which he's been totally involved in this, with his heart and mind in this. When I saw around, my first thought was that in this galaxy of learned gathering, I am possibly the only odd one, in the sense that I am neither a member of judiciary, nor a law-knowing person, nor even qualified or eligible to be a member of a CAT bench. Something which Arjun ji can be. क्योंकि जैसे उनका परिचय पढ़ रहे थे कि वो पूर्व सिविल सर्वेंट हैं और कैट के एडमिनिस्ट्रेटिव मेंबर बन सकते हैं, लेकिन हम तो उसके भी काबिल नहीं, और इसलिए क्वालिफिकेशन तो है. So from that point of view, I think I am here to actually learn from you all, also to gather some inputs, go home and introspect and try to do the course correction which is required, at least at the level of the ministry. As the chairman was mentioning, CAT was established way back in 1985 as a part of Article 323A. And the purpose possibly was twofold. A, to bring ease of justice for the government employee, so that he doesn't have to knock at the doors of the court, the High Court. And B, of course, to reduce the backlog in the High Courts. And there are a number of cases, of course, in services. We have the promotion cases, we have empanelment cases, we have corruption-related cases, we have disciplinary-related cases, and several other. And the composition of CAT was also therefore very thoughtfully decided upon, to have one judicial member, one administrative member. And if one of the important objectives of having CAT was to reduce or to bring in ease of justice, I think the chairman has abundantly given you figures. And one of the issues flagged in the last conference was that many of the benches are having vacancies which are coming in the way of speedy or timely justice. I am glad, and I am also glad the chairman has himself endorsed that. With the personal intervention of Prime Minister Modi, we were able to, by and large, fill all the vacancies now. But the fundamental question remains that we had to be constrained to bring in an amendment, which is very gracefully tended to be forgotten. We had to bring in an amendment to have an administrative member also as the head of the bench, which was not so in the original act. And I don't know why we had to do so, because many of the benches didn't have a person to head. We were short of judicial members. Now, as someone who is a stranger to this domain, but I have been a researcher all my life, I was trying to understand why it was so. Somebody said many of our judicial experts don't find these assignments very attractive. Some others said they had more alternative options. Some said there were also other much more lucrative avenues awaiting them. अब ज़्यादा बात कर नहीं सकते, क्योंकि जजेस के आगे ज़्यादा बात करो तो जजेस जल्दी खफा हो जाते हैं. और आम इंसान खफा हो तो जज डांट भी सकते हैं, लेकिन अगर जज खफा हो तो हम डांट भी नहीं सकते. And to tell you honestly, I was not very sure whether we should go ahead with this amendment. Mr. Arun Jaitley was around there, and I had a very close relationship. I mean, not a single day passed when we didn't spend an hour or so together. And he was also my immediate reference point for many a thing. So I actually went to him and I said, "So do you think it will be," because to my mind it appears, a non-judicial member writing a judgment. And he immediately said, "Yes, you're right. How can that be? How can a non-judicial person be assigned to write a judgment?" So I came back, was not sure how to go about. But a few days later, two very senior officers, whom I had every reason to trust and believe, they convinced me. They said, "Look here, Doc, you are right, but we don't have, people don't come forward to take this assignment. Even after retirement, they have very many other better things to do, which they find more attractive, which is lesser said, but often practiced. And therefore, we would not be able to meet this requirement of having the benches in the manner that we wish to." But then I said, "How would the judgment be written?" He said, "No, most of the service matters are related to the administration, and after 30, 35 years of service, even an IAS officer gets to know the rules and can manage that." So finally, we brought in that amendment. And why it happened, I'm sure one day somebody will take up this subject for the future generations to ponder about. Or maybe the founding fathers of CAT could not envisage that there would be times when the esteem of being a member of CAT would be under question. Nevertheless, I think now that the vacancies have been filled, the time is to move on to the next level, to the modernized management system, which we are now trying to introduce, led by the chairman, use of technologies like the AI, and then of course the judicious use of AI. And I think nobody is better qualified to ensure judicious use than a judicial member. Of course, we have introduced e-filing of cases. Virtual hearings have been there, as a result of which even during the COVID pandemic times, there was not a single disruption or delay happening. Digitization of the judicial records has started for easy access, for speedy procedures, for paperless environment. And now we are into unified digital platform where on a single platform we could access files, we could track cases, and we could also receive multilingual versions. Now, as far as the issue of infrastructure is concerned, I'm glad that it was during this government that most of the CAT benches have received their own buildings. Very recently, I had the opportunity of accompanying the chairman to Lucknow. We had one at Gomti Nagar. Earlier, we have had one at Jabalpur, and so on and so forth. And he said there are only 7 or 8 more left to be done, but the process of acquiring land for the respective states, etc., is in the process. And therefore, I think now is the time we could adopt best practices. Now, a number of judges, number of benches have best practices which are worth exchanging. We could even prepare a manual done in the other department I'm associated with, in the Department of Administrative Reforms. We could actually use them as online modules for others to follow. And one thing which I would like to suggest to the chairman, of course, I've already talked, but I think I must share to you, is the performance benchmarking could be adopted. Because I was closely associated with the exercise of aspirational decision, proved to be one of the most successful ventures being emulated even by the other countries now. We had marked about 40 indices, and depending on each index, it was the true spirit of competitive cooperative federalism. So here also we could identify some of the indices, like for example, the disposal rate, the pendency reduction, the average time of adjudication, the adherence to the procedural timings or the timeline, the extent of the use of technology, the satisfaction of the litigant. That's why I said we have to use AI, because we have the experience of having introduced a grievance redressal system called CPGRAM, which is again to be proved to be a global success story. We have 95 disposal rate as we have now, the chairman mentioned. But I suggested to the secretary, who is incidentally over here, I said disposal rate is 100%, but nobody is happy. So he looked back. I said that is something which is beyond the beyond the spectrum of a grievance redressal officer or a lawyer. And in the West, they have started talking about something like happiness index. So we virtually introduced a human component last year. After redressal of every case, a human person talks to him. If that could be done, could be also the answer to what Honorable Law Minister was very rightly mentioning. For every judgment, you have an appeal. And therefore, and as the Law Minister very rightly mentioned, if the core purpose of CAT was to reduce the backlog in the high courts and to ensure easy, accessible justice, then would we be living to that objective or ideal if we have this culture? If the employee gets a judgment favorable to him, the department goes to the court. If the department goes, then the employment comes. So I think it's time for us to ask, have we actually introduced ease of justice, or we have just introduced one more step into this at the cost of the state exchequer, time and whatnot? And what could be the solution to that? Do we need some checks? Do we need some embargoes? Do we need some kind of a code? Because this is something which comes up every conference. And again, we are the same. I don't have to talk much because the judges impose laws and rules for others. So the physician can heal thyself. Or we simply leave it to the integrity of all those concerned. Because we have all the technology available to us, we have all the buildings, headquarters, but unfortunately, government can't provide you with an alternative for integrity. And therefore, you are better placed to educate me, others like me, how best to go about. I leave it to that. Once again, compliments, Chairman More.
Thank you, sir, for those kind words. It is now my highest honor to invite Honorable Mr. Justice Bhushan Ramakrishna Gavai, Chief Justice of India. Justice Gavai, elevated as the 52nd Chief Justice of India in May 2025, has had a distinguished judicial journey from Bombay High Court to the Supreme Court and now to the nation's highest judicial office. He is celebrated for his landmark contributions to constitutional law, a historic milestone in the annals of the Indian judiciary. It is our privilege to hear his guidance today. May I request now Honorable Chief Justice of India, Justice B.R. Gavai, to address this august gathering.
My esteemed colleagues from the Supreme Court, Justice Maheshwari, Justice Satish Sharma, Justice Prasanna Varade, Justice Bishnoi, Honorable Shri Arjun Ram Meghwalji, the Union Minister of State for Law and Justice, Dr. Jitendra Singh Ji, Minister of State, Ministry of Personnel, Public Grievances and Pensions, Honorable Justice D.K. Upadhyay, the Chief Justice of Delhi High Court, and all the other colleagues from the Delhi High Court, Shri Venkatramani Ji, the learned Attorney General for India, and the learned Additional Solicitor Generals present in the audience, Honorable Shri Justice Ranjit More, Chairperson of the Central Administrative Tribunal, and all the other chairpersons and members of the state administrative tribunals, as well as the members of the Central Administrative Tribunal, Justice Menon, the Chairman of the Armed Forces Tribunal, Justice Mishra, Chairman of GST Tribunal, Justice Sanjay Yadav, the member Lokpal, Srimati Anju Rathi Rana, the Secretary Law, and the other secretaries present here, the President and Office Bearers of the Central Administrative Tribunal Bar Association. I see quite a large number of the senior advocates from the Supreme Court, as well as the other lawyers from the Supreme Court. Conference 2025. As a matter of fact, it's a personal pleasure for me to be here. The chairman of the CAT, Justice More, and me started practice together around 41 years back at Bombay. Our another friend, Mr. Alparam Nadkarni, the former Additional Solicitor General and Senior Advocate, is also present amongst the audience. And our friendship for last 41 years is as it is till today. And when he was the Chief Justice of the Meghalaya High Court, I had also visited the beautiful Chief Justice's house in the Meghalaya, wherein I think many of us have had the pleasure of hospitality. Let me begin with congratulating the Central Administrative Tribunal for envisaging this conference, where chairpersons and members of all the central as well as the state administrative tribunals can come together and discuss the working of the tribunal and the challenges they face and brainstorm solutions to enhance efficiency and accessibility. The spirit of collaboration and problem solving which will guide this conference was also the guiding force for the enactment of the Administrative Tribunals Act 1985. This act was intended to establish bodies that would ease the burden of the courts by dealing with the service matters. As a result, these tribunals were designed to improve efficiency and access to justice for government officials. The Central Administrative Tribunal has worked tirelessly to achieve this goal in the 4 decades since its inception. CAT's disposal rate bears testimony to its sustained efforts in ensuring improved access to justice. For instance, the law disposal rate of 94% compared to the number of cases instituted annually. CAT also maintained an admirable disposal rate of 91% between 2015 to 2019. A look at the current disposal and pending case status on CAT's website also reveals that CAT has disposed of nearly 4 lakhs of the 6 lakh cases instituted in the tribunal so far. These numbers reflect the immense effort, discipline, and dedication that have gone into making of tribunal a functional and a responsive institution. Yet, while it is important to celebrate these achievements, it is equally crucial to acknowledge that statistics cannot be a sole measure of justice. Other factors such as consistency, transparency, and public faith must also be considered. We must therefore also reflect on the continuing challenge of pendency. Despite commendable disposal rates, pendency of administrative tribunal remains a significant concern, as it is so even with the pendency in the courts. The Law Commission reported that as of July 2017, more than 44,000 cases were pending before CAT. This number has grown significantly over time, with over 1 lakh cases currently pending at the CAT and numerous other pending at the state administrative tribunals as well. Another persistent problem in this regard is with multiplicity of appeals which arises from the tribunal's decisions. The Honorable Law Minister referred to it, and we come across various matters when even after the concurrent findings of the Central Administrative Tribunal and the High Courts, still appeals are filed, SLVs are filed before the Supreme Court. Some of the learned Additional Solicitor Generals are present in the court and they know what my approach is to. But in every matter, and therefore, as suggested by the Honorable Law Minister as well as Shri Jitendra Singh ji, and because always the bureaucrats are afraid of taking any risk and they want to pass on the work to the courts. But if you can have some central agency to filter as to whether really the matters deserve to be appealed or not, that will greatly reduce the pendency of the matters before the, if a nodal agency, because I had practiced, my colleague Justice Amri is also present here, when I was in Nagpur, we had issued directions that in every department and every collector office, there should be a nodal officer who should scrutinize as to whether the matters deserve to be appealed or not. if I think such filter is used, it will greatly help in reducing the pendency of the matters. Although citizens' right to appeal is the cornerstone of justice, this process often results in the lengthy litigations, spanning years, therefore undermining the purpose of establishing tribunals. Delay in the adjudication is the government officials and officers reach the age of retirement before their cases are finally resolved. No doubt that it is true that even after retirement, the post significant professional and personal challenges. These are problems that demand urgent attention and systematic effort. In order to address this issue, there is a need for a greater consistency in the tribunal's rulings and increased transparency in their functioning. A citizen who approaches a tribunal must feel that the decision rendered is a well-reasoned. This consistency is as much a product of institutional culture as it is of structural reforms. As is widely said, that the reasons are the live link between the consideration and the result. Many of their members come from administrative services, while others come from the judiciary. Although this diversity presents a strength, since it brings together judicial acumen and administrative experience, it also makes it imperative that members are consistently trained and held to uniform standards of eligibility and conduct. Judicial members would benefit from exposure to the nuances of public administration, while administrative members would require training in legal reasoning. I may not be taken, because nowadays you don't know what you say and what comes in the social media. But as a judge, I have personally noticed that some of the judges coming from the administration, they do not forget that they come from the administration, and they are averse to passing any order which would be against the government. So I think they should reflect on that. The regular workshops, conferences and training programs conducted by the judicial academicians can prove invaluable in this regard and greatly enhance the effectiveness of the tribunal members. Furthermore, if a uniform appointment process is enacted with clear eligibility criteria, this would abate all questions of arbitrariness and reinforce the trust of the citizens in the tribunal. Additionally, as I had previously mentioned, such a system would also ensure greater uniformity in judgments, thereby strengthening the credibility of the tribunals. While I am on this issue, and since both the Honorable Law Minister and Jitendra Singh ji are present in the court, one of the issues that the government needs to address urgently is the service conditions of the members of the tribunal. If the government desires that the retired judges of the High Court and good judicial officers should add on the officers of the tribunals a quick relook at the service conditions of the chairmen and the members of the tribunals, I think is the need of the day. The second area I wish to highlight is the need for a centralized data platform. National platforms such as the National Judicial Data Grid or the National Justice Clock provide comprehensive data on the functioning of the courts at the district, High Courts and the Supreme Court levels. These details include case filings, disposal, and pendency data. However, no such database exists for the tribunals. Although CAT provides a brief overview of pending, disposed, and filed matters on its homepage, a comprehensive resource where such data can be found for the central and the state administrative tribunals would provide more uniformity in accessing data. Additionally, it would also empower litigants to track their cases with greater ease. Such uniformity in data will also foster a culture of comparability amongst the tribunals, allowing policymakers, researchers, and the court to identify best practices as well as areas which may require urgent attention. Such a database where tribunals regularly update the status of each case reviewed by them would also greatly improve the tribunal's sense of accountability and transparency. The Honorable Minister for Personnel and Public Grievances and Pensions has already flagged about the issue of the technology and the AI. In the Supreme Court, we are using AI for categorization of the cases as well as for translating the judgments in around 17 languages so that the litigants know what is written about their case. One crucial aspect that I would also like to discuss about the conduct of the judges, the judicial officers, and also the quasi-judicial officers. As many of you must be knowing that in the All India Judges case, we have now reintroduced the requirement of a practice of 3 years for the law graduates to be eligible for the examination of the JMFC. We had done so after we collected the data from all the states as well as all the high courts. And it was noticed that the fresh graduates who did not have any experience of the or exposure to the court, they would, the chair would go to their head on the very first day, and they would browbeat or ill-treat the lawyers with the standing of 40 years and 50 years. And therefore, we thought that it was necessary that the candidate, before appearing for the examination, must be exposed to the nonsense of the court practice and procedure. Recently, we also noticed that due to the conduct of some of the judges, there is a discontent in the bar. I had read a newspaper item or on a Google, wherein because of one judge in one high court, I won't name the judge and I won't name the high court, a young lawyer was so browbeaten that he became unconscious in the court. As judges, we must also accept a position that both judges as well as the lawyers are like two wheels of the golden chariot of justice, none superior, none inferior. Unless both the judges and the lawyers work in together, the institution of administration of justice, which exists for the last citizen of this country, cannot function properly. As the judicial officers, as the judges, as the members of the tribunal, we wield immense power, but we must carry this power with the utmost humility and responsibility. All litigants who appear before us do so with the faith that they will receive justice before us, and therefore our judgments should not be colored. I urge everyone to honor this responsibility, not just within the official spaces, but outside as well. In many ways, our roles are those of a leader. We will shape the lives of several thousands of citizens through the outcomes that we determine, thereby also affecting the faith of the citizens in the country's judiciary. Thus, in our capacity as the judicial or quasi-judicial officers, we must remember Martin Luther King's words, and I quote, "We need leaders not in love, leaders who can subject their particular egos to the pressing urgencies of the great cause of freedom." As we reflect on these themes, I encourage you not to see them as criticisms, but as an opportunities which can inspire change. They are points for collective reflection so that we may come up with innovative solutions to strengthen the tribunal system. The Central Administrative Tribunal and its counterparts in the states have already played a transformative role in reducing the burden of courts and in improving access to justice for countless citizens. We must now build on that legacy and further strengthen it. I am confident that the deliberations at this conference will produce valuable insights. It is my hope that today's conference will help us improve the legitimacy of tribunals in the eyes of the people. I hope the discussions in this conference prove enriching and that each of you returns with renewed energy to carry forward this work of strengthening our institutions. I would again thank my dear friend, Justice Ranjit More, for inviting me to inaugurate this conference. As a matter of fact, we were scheduled to go to Bikaner, but then we changed our program and we abided by command of Justice More, and from here the Honorable Law Minister and Justice Bishnoi and I will be from the Bharat Mandapam will be going to the sand dunes of Bikaner. So thank you very much. I wish you all the best for today's day-long conference. Thank you.
Thank you, sir, for those profound words that will inspire and guide us all. To bring this inaugural session to a close, may I now invite Honorable Mr. Justice R.N. Singh, Judicial Member, Central Administrative Tribunal, Principal Bench, to deliver the vote of thanks.
Honorable the Chief Justice of India, Mr. Justice B.R. Gavai, sir, Dr. Jitendra Singh ji, Honorable Union Minister of State for Personal Public Grievances and Pension of Minister of State for in the PMO, Minister of Science and Technology, Independent Charge, Honorable Judges of the Supreme Court, Honorable Union Minister of Law and Justice, Independent Charge, and Minister of State for Parliamentary Affairs, Sri Arjun Ram Meghwal ji, Learned Attorney General for India, Honorable Chief Justice of High Court of Delhi, Honorable Judges of the Delhi High Court, Honorable Chairman, Presidents of various tribunals, Honorable Namaskar and a very good afternoon to all of you. I feel immensely privileged and honored to extend a heartfelt thanks on behalf of the Central Administrative Tribunal on this momentous occasion of our 10th annual conference held at this grand venue of Bharat Mandapam. At the outset, I express our deepest gratitude to the Honorable Chief Justice of India, Sri Gavai Sir ji, for gracing this occasion with his august presence. Sir, your kind presence amidst us has added to the stature of this conference. Your kind words of wisdom will not only encourage and motivate us, but will also serve as inspiration to re-dedicate ourselves in the cause of justice. I would like to extend thanks to you for delving upon various dimensions associated with judicial work. I'm sure it will serve as a guiding light in strengthening the institution of administrative justice in our country. I also extend our sincere thanks to the Honorable Judges of the Supreme Court for their august presence in this session today. Your kind presence is a reflection of continued support and insightfulness perspective which would encourage us towards collective pursuit of judicial excellence. Thank you very much for gracing the occasion, sirs. I would like to extend a special thanks to Dr. Jitendra Singh ji, Honorable Minister, who holds many positions in the Government of India and whose unflinching commitment to administrative reforms and governance has been instrumental in empowering institutions like ours. Sir, your vision encourages us to continue evolving in sync with needs of changing administrative landscape. We are especially thankful to you, sir, for taking a special interest in ensuring the full human resource is provided to this tribunal for better efficiency. We equally honored by the gracious presence of Honorable Sri Arjun Ram Meghwal ji, Union Minister for Law and Justice, whose concern for justice is ingrained very deep in his heart. Honorable Minister has rendered a yeoman service in the area of his responsibility in the Union government. He is a pillar of strength for judicial institutions across the country. Sir, your address today was not only informative, but deeply motivating too. I warmly thank the Attorney General for India for appreciating our acceptation and sparing time to be part of this program. Sir, your kind words of encouragement come from your long experience in practice of law before various constitutional courts in the country. We Deeply appreciate your concern for easy and faster justice, sir. Your insights and contribution to the field of public law continue to inspire legal minds across the nation. I would like to extend warm regards and thanks to the Honorable Chief Justice of Delhi High Court, Honorable Justice Upadhyay, Honorable Judges of the Honorable High Court of Delhi. Their august presence stimulates us to strive hard in furtherance of cause of justice. Their constant support and guidance immensely help us in handling complex matters with each. I also wish to express my gratitude to various chairmen, including the chairman of Armed Forces Tribunal, Honorable Justice Menon, other chairmen and presidents of other tribunals, former chairman of this tribunal, Honorable Justice Kohli, honorable former vice chairman of this tribunal, and honorable former members of this tribunal. Your esteemed presence motivates us to carry forward the cause of justice with renewed dedication. The wisdom and guidance you have shared remain invaluable in helping us in discharge of our responsibility with confidence. We are also grateful to and thankful to Honorable Justice Reddy, our former chairman, for his august presence amongst us. My thanks is due to the Honorable Chairman of the Central Administrative Tribunal also, and the members of this tribunal who have come from various benches. I must especially mention that Honorable Chairman Sir has been taking keen interest in ensuring purposeful and smooth deliberation in this conference. He has spearheaded and monitored progress of various activities associated with the smooth conduct of this conference. No words are sufficient to express thanks for continued support and commitment with immense dedication. I also thank honorable members for sparing time from their busy schedule to be part of this conference. My duties to thank would be incomplete if I fail to mention the continued support and participation members from the bar who have wholeheartedly supported us in making this event a success. I express my sincere appreciation and thanks to every one of them. I warmly thank officials of Government of India from various ministries and departments. I also extend my thanks to members from electronic and print media present in this August gathering to cover the event. Of course, with one request to them to provide widespread coverage to the event. Thanks are also due to the management team and staff of Bharat Mandapam, the Soka Hotel, New Delhi, as well as officials of Delhi Police for assisting us in making arrangements to organize this conference at this venue of international repute. A conference of this scale would not have been possible without the intense involvement and tireless effort of the organizing committee, officers and staff of the Central Administrative Tribunal. I would like to especially thank my colleague, Honorable Mr. Manish Garg and Honorable Mr. Rajendra Kashyap, who have minutely deliberated on every detail and monitor the progress of every activity. The efforts made by them as well as by the teams under the direction and leadership of the learned principal registrar of the tribunal, learned registrar and other senior officers of the tribunal are also commendable. I thank them for their unflinching commitment and sincerity. Once I again thank each one of you for your presence, participation, and invaluable contributions. Jai Hind, Namaskar.
Thank you, sir, for those kind of acknowledgements. May I now request everyone to please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
Ladies and gentlemen, that concludes the inaugural session of the 10th All India Conference of Central Administrative Tribunal 2025. We thank all our esteemed dignitaries and distinguished guests for their gracious presence. May I request our honorable guests to kindly proceed for high tea. और मैं अन्य सभी लोगों से अनुरोध करती हूँ कृपया इस द्वार से भी हम जा सकते हैं और उस तरफ जलपान का प्रबंध है। धन्यवाद।